Good afternoon, and welcome to this one in a series of seminars and webcasts that we're holding to help people understand AB26-1X and AB27-2X new legislation that's been enacted by the state to, first of all, kill redevelopment agencies and then allow agencies to come back to life if they agree to making substantial payments this fiscal year and every year thereafter. I'm Shirey. I'm the Executive Director of the California Redevelopment Association. With me is Brent Hawkins, who is our Legislative Counsel and also Corporate Counsel with Best and Krieger. As we indicated in our promotional material for this webcast, we welcome questions being sent to us ahead of time. I've received quite a number of those, but you can also ask questions during the course of this webcast, and also are we able to handle questions through, not through the telephone, only if they send them to us through the webcast. So those of you that are listening on the line can ask questions, but you can do it through the webcast facility. I want to start by talking about something that many people want to know about, and that's our lawsuit. We have been hard at work preparing that lawsuit. Our attorney is Steve Mayer with the firm of Howard Rice based in San Francisco. He feels that we'll be able to file fairly soon, any date now, but I still can't give you a specific date as to when we will file. One of the questions that we get asked is, well, what about an injunction or a stay? We'll file for the stay along with filing the regular lawsuit. It'll be all one filing. And so what we hope to what we will ask the California Supreme Court to do is stay the implementation of this law in order to, quote, maintain the status quo while they take extra time, of course, to decide the merits of our case. We've been asked, well, how and when will we know about the stay? Well, the court will be given some time and will take some time to act on the stay. We'll ask the court to act on the stay by mid-August. We think that's a reasonable period of time. The court will be giving the Attorney General on behalf of the state an opportunity to respond. And so it's not one of those things where a stay will be asked for today and acted on tomorrow. There'll be a short period of time in there. But let me ask Brent. Brent, one of the questions that we get a lot is, okay, well, what's the stay actually going to stay? What will be held in abeyance if the stay is granted? Try to explain that in general terms.
The answer, unfortunately, is it depends. The stay, of course, if it's granted, will be, the wording will be determined by the court, and the court will decide exactly which actions will be stayed and those that won't. We'll, of course, ask that all of the legislation, the entire legislation, be stayed. But if the court feels uncomfortable with that for any reason, we would ask that certain, basic aspects of the legislation be stayed, such as the dissolution of agencies on October 1st. We want to be sure that agencies and cities still have the ability to go forward and adopt their continuation ordinances if they want to. So it's difficult to predict at this stage exactly what that state is going to allow or not allow. I think the best thing we could do at this point in time is to say that we will, as soon as there's an action on the stay, we'll get information out immediately about what is or is not permitted.
So the point is that the court may not stay the entire set of statutes. The court may stay pieces of it, and we feel that the most important pieces of that to stay are, of course, those provisions which call for agencies to be dissolved.
Right.
Another important provision that we would probably like to see maintained, though, is the provision which allows agencies to pass ordinances in saying that they will make those payments and in effect stay alive.
Right.
It wouldn't matter to us if the court stayed the requirement of the state to provide the exact calculations on the payments. So, for example, that's something that could go forward.
Certainly.
So it's really not necessary for us to ask for everything to be stayed, but obviously there are very important pieces of this legislation which we want to have held in abeyance until the court decides the larger issue.
Right.
Hopefully that answers some questions that people have. Now, a couple of questions that we've gotten here with respect to the stay. People ask about the, quote, poison pill provision. First of all, Brent, explain to everybody what that poison pill provision is in the legislation, and then explain what a stay might mean with respect to that poison pill provision.
Well, the poison pill provision says that if there is litigation that is filed challenging this legislation, and the legislation is ultimately found to be unconstitutional, that agencies would no longer have the ability to issue bonds or enter into other kinds of indebtedness. That's what is referred to as the poison pill provision. We think that provision is clearly unconstitutional on a number of grounds. The most obvious of which to me is that it simply can't be the law that successfully exercising a constitutional right carries this kind of a penalty. Now, I think as far as the application of the stay to the poison pill, I guess I would be surprised if the stay dealt specifically with the poison pill provision, because that poison pill provision is forward-looking. That it would only come into effect after the case has been decided, and if the statute has been declared unconstitutional.
I just want to draw some additional emphasis to this provision because I think it shows something about the character of this legislation. This is a mean provision. This is a provision that says that if you dare to challenge the state of California, they're going to come back at you and prohibit you from issuing bonds. Mm-hmm. That's got little to do with the issue. Frankly, that's just another way of trying to penalize local governments for challenging this legislation.
It's very mean-spirited.
It's very mean-spirited in that respect, for sure. One of our members worries that with respect to the lawsuit, that the court may say, well, the second bill, AB 27, is invalid.
The resurrection bill? The
resurrection bill is invalid, but leave in place AB 26, which is the dissolution bill. Mm-hmm. What's the possibility of that, and how do we respond to that sort of possible outcome?
It's theoretically possible, but I think the chances of it actually happening are very remote. I think the two bills are so closely related that they're going to stand or fall together, and it's very unlikely that a court would separate them and find one constitutional and the other unconstitutional.
And let me just share with our viewers that that's the same response that Steve Mayer, who is our lawyer for this lawsuit, would give. He feels that it's just highly unlikely that the court would separate the two and found one valid and the other one not. Hopefully that's going to be the outcome, that they'll both be thrown out, and we won't have that worry. Another general question that we've gotten, Brent, is that people want to know a little more specifically from you, what does it mean in terms of their operations if the stay is granted? I mean, what can they do and what can't they do under a possible stay? I know that you've just explained, that we don't know exactly what that stay will contain, but can you speak generally about how agencies may or may not be able to operate under a court stay, a court-granted stay?
Well, I think what we would hope is that agencies that opt in and pass the continuation ordinance would be able to operate under those provisions of the of AB27 that permit agencies to operate more or less as normal. So, for example, we would of course want the time for the payments in January and May to be stayed, because it may not be possible for the court to act that quickly. But other than that, I think those agencies that opt in and pass the continuation ordinance would be able to continue to operate more or less as usual.
Okay. Along those same lines, we've gotten lots of questions wanting to know what agencies can and cannot do now. Legislation has been signed by the governor. It's in place. Agencies are still considering whether they want to pass ordinances or go out of business because they don't have the resources to do that. So we've gotten a series of questions along the lines of what agencies can and cannot do. One of the questions, for example, is, does the legislation invalidate all existing agreements between the city and the agency, or that could be asked of the county or the agency, or new obligations? So does it invalidate existing agreements between the city and county and the agency?
I think not until, I mean, the way that I read the legislation, those intramural agreements between the city and the agency, or the county and the agency, remain valid until October 1. So until then, the city and the agency can continue to operate under those agreements. And of course, any agreements or contracts with third parties continue to remain valid and would continue to be valid after October 1st. After October 1st, there are provisions in the statute that are intended to invalidate most of those intramural agreements. A few of them are accepted from from that provision. Cooperation agreements that were entered into at the time that the agency was formed, or the redevelopment plan adopted, or one exception. Cooperation agreements that were entered into in connection with the issuance of bonds, where the agency agrees to reimburse the city or joint powers authority for debt service. Those kinds of agreements would not be affected, but literally, as the statute reads, most, if not all, of the other agreements between the agency and the city would be invalid as of October 1st. Now, the successor agency could look into entering into a new agreement with the legislative body that would require the approval of the oversight board. Or agencies can take the position, and I think many will, that the state doesn't have the authority to invalidate those agreements, and so there may be disputes, perhaps even litigation, arising out of that.
Okay. Here's a worry. Does the legislation affect existing bonds issued by the agency?
No.
Okay, very simple answer there. Bonds aren't affected by this legislation, or if they are affected, that's litigation too, and
yeah,
that's probably a certain loser by the state. Does the legislation invalidate real property transfers that occurred between the city or county and the agency? For example, deeds that have been transferred.
Yeah, I think there's no simple answer to that. It depends on the circumstances. Clearly, the intent of the legislation was to invalidate those transactions that occurred between January 1st and the effective date of the legislation. Whether the legislature can actually do that, again, I think is an open question. transactions that predate January 1, 2011, I think ought to be valid, and although there is some awfully broad language in the statute.
Okay. Here's a more specific question. Agency wants to know, can we amend a consultant contract to add additional services before we adopt the ordinance, paying, the pay-to-play ordinance under AB 27?
Probably not.
Okay.
That would be a new agreement, and until the city has adopted the ordinance agreeing to make continuation payments, the strict limitations of AB 26 would apply, which prohibit any new agreements or any amendments to existing agreements. Now, the one exception that I can think of would be agreements that contemplate future changes. For example, many construction contracts have a provision in it for change orders.
Mm-hmm.
Those are built into the contract, and change orders could be issued under the provisions of that construction contract, or some other contract that had already built into it a provision for a change. I think could be carried out, but if it's a new agreement, new terms, additional money, more time, those, unless it's specifically provided for in the agreement, I think that would be prohibited until the continuation ordinance is enacted.
Okay, what about contracts that were in place before June the 29th, and they're just ongoing contracts?
No problem. You just continue to implement those, what the statute calls enforceable agreements, enforceable obligations.
Now, we've also received a series of questions that I'll say are related to timing. Several agencies have asked us, well, what about if we enter into that, we pass that ordinance that we're going to pay, but lo and behold, comes January the 15th, we find out we don't have the money. What happens if we pass one of those ordinances but we can't pay?
Well, there are two possibilities. One is we just rescind the ordinance. There's nothing in the statute that limits an agency's ability to rescind a continuation ordinance. The other possibility is that you just wouldn't pay. And in either event, I think the outcome is the same, and that is that the agency would be subject to the dissolution provisions of AB 26, and the agency would be out of business.
Sort of a similar question is, well, what happens if that occurs, say, 2 years down the road, where the agency decides it just can't make those ongoing payments?
Right, I mean, the answer is the same, except that you would go back to, if you're looking at the validity of agreements or obligations that have been entered into in the interim, you go back to the January 1 preceding the date that the agency fails to make the payments, and to determine the validity of those contracts and other obligations.
But Brent, one of the things that's different about this legislation as compared to the previous ERAF or CRAF shifts is that this legislation specifically says these payments are an obligation of the host city or county, whereas the previous bills all said that it was really the agency who was on the hook to make those payments. First of all, what's the significance of that? And then related to that, one of our members wants to know, well, if this ordinance obligates the city or the county to make those payments, is there some way in which the state could come back on that city or county to make that payment if they've passed that ordinance and then find out later on they can't make the payments?
No, the only penalty or the only remedy that's provided for in the statute if the city fails to make the payment is that the agency becomes subject to the dissolution provisions of AB 26.
The question is there a new liability that the city or the county incurs by passing that ordinance?
Well, yes. I mean, they do incur a liability to make the payment. It's the city's or the county's obligation to make the payment. The question that I was answering is, you know, what's the outcome or what's the result if they fail to honor that commitment? And the answer is the agency goes out of business.
Okay. Maybe we need a clarification on this one. Here's a question. Do the continuation payments include the new pass-through to schools or just the 2 lump sum payments in the upcoming 2 years? I think we need to clarify that.
Yeah, I mean, I understand the question to ask whether there are payments in just 2 years or whether there are ongoing payments. And the answer is that there are ongoing payments, that there will be one payment that's calculated on one formula for 2011-12, where the state is trying to raise $1.7 billion, and then beginning in 2012-13 and ongoing for the remainder of the life of the redevelopment project, there would be annual payments that are based on the state raising $400 million through these payments.
Yeah, and we don't really consider those payments to be pass-through payments in the sense that there are agencies that have contracts in place for pass-through payments, and there are provisions in law since 1993 which require pass-through payments. So I think people would be wise not to confuse the two. These are not really pass-through payments in the sense that agencies are making other pass-through payments to schools, counties, special districts, what have you.
Right, I think people have been referring to these as ransom payments as opposed to pass-through payments.
Probably a more appropriate term than pass-through payments. Here's a question from one of our members who has multiple project areas. And the question is, do we have the option of allowing 1 or 2 of those project areas to be dissolved and maybe maintaining a couple of our other project areas? And if we do that, will the payment that we're obligated to make under this legislation to stay alive, is it reduced because you know, we let 2 project areas be dissolved and we keep 2 other project areas going?
Yes, I believe the answer is yes on both counts. Yes, you do have that option, and yes, the payment should be reduced because the method of calculating the ongoing payments, the 2012-13 and going forward payments, allows for adjustments based on the growth or reduction in tax increment of the agency. And if your project expires and you're no longer receiving tax increment from that project, then the amount of the payment should go down.
Okay, is that true of the first year when $1.7 billion is due?
No, the only ability you have to change that is this appeal that's provided for after you receive notification from the Department of Finance of the amount of the payment, which the Department of Finance will calculate based on the 2008-9 Controller's Report. You can then come in and appeal that within 2 weeks after receiving it on just 2 fairly narrow grounds. One is that the information in the Controller's Report is inaccurate, and the other is that your debt service has gone up since 2008-9.
Okay. Another question has to do with caps. Agencies have caps. So the question is, do these continuation payments that we have to make, do those count against the cap or not, the tax increment cap?
Unfortunately, no. I mean, that was a provision that we had included in most of the ERAF and CRAF bills, that those ERAF and CRAF payments would not count against the cap, but it was not included in this legislation.
So these payments count against the cap?
Yes.
So even though they're getting no use whatsoever from this money, it's counting against the maximum amount of money that they can receive.
Yes.
sort of another aspect of this legislation which we would call mean-spirited in its approach. Now, another question comes up if an agency is considering issuing tax allocation bonds, which would be secured by their 80% tax increment. Would they be better off to issue those bonds before November 1st of this year, and in that way lower their voluntary contribution payments?
Well, unfortunately, I think it's unlikely that agencies will be able to issue bonds before November 1st. It's my understanding that with the passage of this legislation and the pendency of the lawsuit, it's unlikely that bond counsel will be in a position to issue a clean bond opinion until that litigation is resolved.
And this is new information. We have actually just learned this today as something that we had wanted to know the answer to, and we think we have some answer to it now, which is that it seems like bond counsels are not going to be able to issue opinions for bonds because of the fact that we are suing and the fact that we are, of course, alleging that law is unconstitutional.
Right.
Okay. Here's a question: will agency debt obligation agreements with its sponsoring agency entered into after January 1st be invalidated if the agency agrees to the voluntary program?
No. The provisions that relate to the invalidation of those agreements are in AB26, and if the agency adopts an ordinance under AB27, the continuation statute, they're not subject to those limitations in AB26.
We always get a lot of questions about use of housing funds. Here's one that we haven't received before. This agency says they're planning to allocate the balance of their non-housing redevelopment funds to their affordable housing program and pay the state. It's actually paying the schools in order to continue as an agency to operate our housing programs. But it says, can we pay the following year payments out of our housing funds?
I'm not sure I follow the question because I don't think agencies have the option to use the balance of their housing fund or to transfer the balance of their housing fund to the city if the city elects to be the successor to undertake the housing functions. The statute specifically says that the housing fund balance would not be transferred and would in fact go into this pot of money that is used to pay obligations, and then the remainder goes out to taxing agencies.
And here might be a source of confusion because the legislation does allow agencies to use their 20% housing set-aside funds during this fiscal year, this budget year, to come up with the amount of money to make that $1.7 billion.
Yes.
But then it says in succeeding years, you cannot use your housing set-aside funds or the accumulated funds for that purpose.
Correct.
So we've had that question a number of times in a number of different ways, and we just want to make that crystal clear to everybody what the intention is there. Let's see. Here's a question about wanting some clarification on the estimated amount of ongoing annual payments to the state. Do they run for the remaining life of the redevelopment project plans?
I think we've already answered that. They do.
They do, and we are not able to calculate those payments for you because we just don't have the information to be able to make that calculation. As Brent explained a moment ago, there is a different way in which those succeeding years are calculated as opposed to the first year payment, which we have calculated, and those numbers are on our website. it says, after we've adopted a continuation ordinance, will we be able to issue tax increment bonds?
But for the problem that we've identified with bond counsel being able to issue a clean bond opinion, the answer is yes. But there is this problem. That is, I think until the litigation is resolved, will prevent agencies from issuing tax allocation bonds.
Okay, so it sounds like issuance of bonds is going to be a problem, at least for some months to come here.
Yes.
Is it possible to pay the initial payment subject to a loan from the city's general fund, thereby creating more debt for the statement of indebtedness and lowering the ongoing annual calculations for payments?
It really depends on the definition of tax allocation bonds. There's some disagreement among the attorneys about whether tax allocation bonds should be limited to just traditional tax allocation bonds where tax increment is pledged directly to the repayment of the bonds, or whether that term would include other forms of indebtedness for which tax increment is pledged as security. And that this is an area where there's some confusion. Unfortunately, many of the provisions in the bill are ambiguous, in some cases contradictory, in other cases unintelligible, and this is one of those areas. This notion of what tax allocation bonds means is one of those areas where there's a lack of clarity, and it's not really possible to give a very complete answer.
Okay, now we explained a moment ago that the legislation makes the host jurisdiction, either the city or the county, responsible for making these payments. Mm-hmm. But there's also a provision which says that the city or county can reimburse itself from its agency funds for those payments.
Yes.
So the question comes in, well, when those funds are reimbursed, can they be spent for anything, or do those funds have to be spent for redevelopment purposes as defined under the Health and Safety Code?
Yeah, and this is another area where the statute is not as clear as we would like it to be. I guess there are two ways of approaching this. One, which would be the most conservative approach, would be for the city to take those reimbursement payments and apply them to general fund expenditures within the redevelopment project area that would be eligible expenditures for the redevelopment agency. I think that would be the most cautious approach. I think a more practical approach is to say that the purpose of this reimbursement payment is to enable the agency to continue to operate, to continue to carry out the redevelopment plan, and that is a redevelopment purpose, and therefore the funds would not be subject to a sort of a line-by-line limitation.
Okay, well, let me ask you this. What if the payment is $1 million, and the city makes that payment on behalf of its agency? Can the city reimburse itself $1.5 million?
No.
Okay, there's a limit, right?
Yeah, it's just...
And so when you look at that limit, there's sort of a practical issue that takes over here, which is that it certainly seems as if the reimbursement is for the purpose of making those payments.
Oh, absolutely. There's no, I mean, if you read the statute, that's clearly what it's there for.
Right. And so, in the absence of specific language, you have to assume that those become just like general fund dollars that can be spent for whatever they were supposed to be spent for previously.
Yeah, I mean, the problem is created by this language in the statute that says that that money has to be used to pay for activities that carry out the redevelopment plan. And it's clearly an attempt on the part of the state to put a savings clause in the statute so that these expenditures would not violate Article 16, Section 16 of the Constitution, which says tax increment has to be paid to retire indebtedness and to carry out the redevelopment project. So that's what the state was trying to do. In the course of doing that, they created this ambiguity about how the money can actually be spent.
Okay. A couple more questions about new agreements. In general, the question is, you know, if agencies are prohibited from entering into new agreements, but then they pass this ordinance committing to making those continuation payments, can they enter into new loan agreements immediately thereafter?
Depends on how you define.
As an example.
Yeah, as an example. It depends on how you define immediately. I would want the ordinance to be effective. So, you know, if there's a publication in 30 days, but once the ordinance is effective, yes, they could enter into those new agreements.
Okay, and we've gotten that question again, just as we did in the last webcast. When is the ordinance effective?
Well, I mean, there are two questions here. I mean, what the statute says is that the ordinance has to be enacted by November 1st. I understand enacted to mean the same as adopted, which to me means the second reading of the ordinance, or if it's an emergency ordinance, it would be the first, you know, the only reading, with the second reading being waived. So the second reading would have to occur before November 1st.
But not necessarily the 30-day
but not no.
Customary period.
That's when that's when it becomes effective. That's not when it's enacted.
Okay, so just to understand that distinction there. A question along with that one was, is ordinance language available? And this week we sent to you just yesterday sort of model ordinance language. It's available now to you. We've sent it to you, and I think we've also put it on our website. But we encourage you not to just use that just the way it is. You still need to work with your agency counsel or your city attorney or county counsel to make sure it's tailored for your particular purpose and needs. But we've given you some language there that other attorneys are using, and so you know, that's now available to you for many of you that have asked us about where can you get language for that ordinance. Okay, another question that we've gotten is that people have read in the language about passing a resolution and then passing an ordinance. What's the purpose of this resolution, Brent, and what is the meaning of that resolution when put in the context of these other questions about, well, what activities can we undertake in the meantime?
Well, the resolution really has no significance as far as those other activities. It's the ordinance that matters. I think that this resolution was added by the state so that by October 1st, they would have an idea of how many agencies are going to make these continuation payments and what the continuation payments would be approximately for their own planning purposes. What the statute says is that if you will not be enacting the ordinance by October 1st, you can adopt a resolution, which is a non-binding, sort of like a non-binding resolution of intent, saying that the agency or the city intends to enact the ordinance by November 1st, and that essentially commutes your execution from October 1st to November 1st, pending the enactment of that continuation ordinance.
Okay. Here's a question from an agency that's worried about being able to cobble together enough money to make the payments to continue in existence. And they're asking the question, if we pass this ordinance to continue in business, can we then refund our debts, our bonded indebtedness, do a refunding loan in order to free up some dollars so that they can make those payments?
The answer is yes, assuming you can get bond counsel to issue an opinion. I mean,
and that's a big question.
Yeah, until the litigation is resolved, that's a big question.
Okay. We got a question asking if we could post a formula for how the new school pass-through will work. I'm not quite sure about that question. If the asker of that question means how did we calculate those payments for the $1.7 billion taken the first year, that formula is posted as part of the material that's on our website. If the person is asking about the formula for the succeeding years, we haven't posted that, but that's where we run into difficulties because we don't have the data to make that. But there's this strange provision in there, Brent, which people have asked us about in terms of, gee, it looks like there's something about, you know, we could somehow get some of our money back if we do this 80% thing for schools. And that's that provision in there which I've asked you about a few times and still remains a little mysterious as to what it means.
Well, it's not well drafted, and I'm afraid there's some mystery is going to remain. But my understanding is that there's a second component to the ongoing ransom payments. The first component, of course, will be based on your previous year's payment, with adjustments up or down for changes in the amount of tax increment. But there's a second component which relates to bonds that are issued after November 1st, 2011. And so if you issue bonds after November 1st, 2011, your ransom payment will be increased by 80% of the school share of the debt service on those bonds. What this is an attempt to remove the school share from tax increment financing. So that basically, on November 1 going forward, agencies will no longer have the ability to pledge the school share of tax increment to new indebtedness. And the way that they mechanically, the state has done that is to say that if you do issue bonds after November 1, 2011, then your ransom payment is going to increase by 80% of the school share.
Okay. So, in effect, when you're doing those projections for future bond issues, you got a new factor to take into account.
Yes.
And that's this kind of offset that you would otherwise have available to you that now won't be available.
You will have less tax increment available to you because of this.
Because of that provision. Okay. Next question that we've gotten is having to do with, well, here's a specific question that this agency says, well, we've noticed that there's a substantial understatement of our debt service in the tables that we published for how it is that we calculated those payments. And the reason probably is because this particular agency has issued significant debt since 2008-9, which is the year that we used, because that's what the legislation specifies, and that's what data is available in order to make those payments. So this question is about, well, what do we do if we disagree with those payment calculations? And there's two provisions in the legislation that deal with that. One is, if you just simply think an error has been made, you can appeal that to the Department of Finance. But the other is that if your debt service payments have gone up by 10% or more since 2008 or 9, you can make an appeal to the Department of Finance.
Yeah, or if your tax increment has gone down significantly, such that it makes a difference of 10% or more in terms of the amount of tax increment that you're devoting to debt service. You can also make that appeal. And my advice would be, I think agencies, they ought to be able to look at the calculations that CRA has put out and their current figures and determine whether an appeal is going to be appropriate or necessary. And if they think it is, they ought to be preparing for that now, because there's a very short window of time, just 2 weeks from the time that they get the information from the Department of Finance and the time they have to file this appeal. So they should be working now to pull all that information together so that they can make a complete submission when they file their appeal.
Okay, and then the next question is, well, where do we file the appeal? You file the appeal with the Department of Finance.
Director of Department of Finance.
Ana Montesantos, I'm sure would love to get your appeal. She's the Director of the Department of Finance, and their address, of course, is at the State Capitol. But one of our agencies has already filed one of these appeals, did it via email, sent it to the department's analyst who handles redevelopment matters, that's Mark Hill. And you can send questions and the issue to Mark Hill, and that's just capital MARK .Hill, HILL, at dof.ca.gov. So that contact person is mark.hill at dof.ca.gov. Next question, we've gotten this one 3 or 4 times. Agencies have asked us, is there some plan to do a pooled financing so that agencies might be able to make these payments, which are so horrendous, particularly in the first year? Recalling that we did this once before, back in 2007. Couple answers to this. First of all, there's no provision in this legislation for pooled financing in order to make these payments, unlike the previous legislation where we specifically included that. You remember this one was passed with about 24 hours notice. It wasn't legislation that we had any input on. But the bigger question is this, and it goes back to what Brent was talking about just a moment ago. How would a pooled financing be done if bond counsel can't give an opinion on such a financing because it's being challenged and on the face appears to be unconstitutional? So I don't want agencies to hold out hope that somehow there's going to be a pooled financing mechanism available for that. I think the chances are there will not be that kind of legislation available or that kind of financing mechanism available. Okay, let's move on. Here's a straightforward question. Brent, person is asking once more, can we just define what we mean by new agreements? Does this mean new projects that have not been authorized by the board yet? Would this apply to new contracts for previously authorized projects? For example, you've done construction, or you've done design, but you haven't done construction. Answer generally what we mean here by new projects, new agreements, and so on.
I think unless you have an actual signed, written contract, it's going to be a new agreement. And the one exception, again, that I can think of is where the agreement itself permits changes, such as change order provisions in a construction contract. But the fact that the agency has authorized the project, has dedicated money for the purpose of the project, I'm afraid is not going to be enough to make what the statute refers to as an enforceable obligation. We need an actual signed written agreement.
Okay. Much more specific question comes from one of our agencies in reference to the frequently asked question document that we put out last week that we tried to provide as many answers as we could to, but this person asked, you know, in our frequently asked questions, we don't specifically mention retirement costs or medical retiree payments as obligations to consider. And then the question is, are these considered other obligations?
They're considered enforceable obligations because they are pursuant to contract. Yes.
Okay, so straightforward answer on that one. I have not been taking questions that have come in. Let me let me take a few of those questions before we continue on with the ones that we got beforehand. First question is, for agencies who borrowed from the Lomont Fund to make their CRAP payments, that is, the last time the state took $2 billion from us, will those loan payments become immediately due and payable upon elimination of the agency? In other words, if the agency elects to dissolve, what happens to that money that was borrowed last year to make the CRAP payment?
Well, unfortunately, this is another one of those where I'm afraid there isn't a very good answer. I can go through the analysis with you, but it doesn't really lead anywhere. The successor agency would succeed to the obligation of the agency to pay back the housing fund. But the housing fund no longer exists. And even if it did exist, that money, instead of being used for housing, would become part of the pot that gets used to pay the taxing agency. So you basically have a situation where the successor agency has an obligation to pay money to a fund that no longer exists. So it's, status of that is unclear at best.
And that's another one of the questions that we receive is that, well, if we go out of business and there's a successor agency, does the 20% still have to be set aside for housing? And the answer to that is no. There is no housing fund afterwards, but as you point out, there may be a previous debt owing to the housing fund. Mm-hmm. Okay. Well, here's a question that we probably should have answered at the outset. What's the status of our prior lawsuit? We have a case pending in the 3rd District Court of Appeal. You want to give us a second update?
That's a case that challenged the prior payment, the CRAP payments, as unconstitutional. The Superior Court decided against us, and we appealed that decision. The case has been fully briefed. It has been since about, I think, February or March. And so we're waiting for the Court of Appeal to schedule oral argument in that case. And we anticipate that they should do so in the fairly near future. I anticipate that the case will be argued in the fall and probably decided by late this year.
Okay.
And I might just add that I think you can expect that whoever loses that case in the Court of Appeal will petition the Supreme Court for a hearing, and that could add up to another year before we get a decision on that case.
Okay. The courts move slowly. Specific question here, does an exclusive negotiating agreement count as an enforceable commitment or enforceable obligation?
In the past I've tried to dodge answering that question directly because to a large extent I think it depends on what the exclusive negotiating agreement says. I think if it's the usual routine exclusive negotiating agreement, 4 or 5 pages long, all it really does is obligate the parties to negotiate in good faith to try and conclude a DDA or an OPA. I think that probably does not qualify as an enforceable obligation. If it's something more than that, that includes specific terms, then arguably it might, but it would really depend on the specific provisions of the agreement.
Okay. Here's a series of questions that we've gotten about successor agencies, that is switching back now to AB26, which is the dissolution bill. In practical terms, who will manage the active projects? Agency goes out of business, but we know projects don't just stop. There are ongoing projects. Not an easy answer there. Presumably the successor agency will have to somehow wind those projects down or bring them to completion.
Yes, and I mean, most agencies have no employees. They contract with their legislative body for employee services, and I expect that in most cases those city or county employees who are working on redevelopment agency matters will continue to do so, since they have the historic knowledge of the projects, and the successor agency, either the city or the county, is authorized to continue to pay those administrative costs within certain limitations. And so I expect it will, for the most part, be the same folks doing the work.
Okay. It says, next question, is there a plan for dismantling required by the legislation? Well, that specific word isn't used, but I mean, it does call for...
There's a structure for transferring assets and obligations to the successor agency overseen by the oversight board and so forth. We've already talked about in some detail. If you're talking about specific agency by agency plans, no, those something that each agency will have to come up with individually based on their own peculiar facts and circumstances.
Here's a question I'm sure you've been asked before, Brent, which is that this agency is, the city advanced money to the agency.
Yes.
Pretty common.
Mm-hmm.
It's been on the books for years. They note it on their statement of indebtedness each year. So the question is, will that receivable survive, or does it get wiped out if the agency is dissolved on October the 1st?
Again, there is language in the legislation where it's clear that what the state wants to do is to wipe out all of those agreements with two limited exceptions. One is if the agreement was entered into within, I believe it's 2 years of the adoption of the redevelopment plan, and the other is if it was entered into in connection with the issuance of bonds where tax increment was being used to reimburse the city or joint powers authority for debt service. My own view is that the ability of the state to just declare that those are no longer valid if they were entered into, at the time they were entered into, they were legal. If they have been performed over a substantial period of time, if others have relied on that performance, I think the ability of the state to invalidate those agreements is suspect, and I know some agencies are not willing to accede to what the statute appears to say, and believe that the impairment of contract provisions in the Constitution might protect them.
Okay. We know that everybody is going through this exercise of trying to decide, well, will we decide to stay alive under AB 27 or will we dissolve? There are calculations being made as to what that would mean both ways. So one of the questions that we've gotten is, well, okay, if the agency is dissolved, and in this case a city agency is dissolved, well, what can the city general fund expect to receive from those former tax allocation monies that now become regular property tax monies?
If you have a financial consultant, they could probably compute that for you. It's just a matter of figuring out how much tax increment is going to be generated, how much of that is going to be needed to pay bonds, debt service, other obligations, how much is left over after deducting all of those obligations, and then applying to that figure a percentage, which is the proportionate share of the city share of the property tax pie. So while we can't answer that question for individual agencies, the information is available, and either a staff person with the right kind of knowledge or a financial consultant can do that fairly readily.
Right. Probably safe to say that in the situation of a city, does that apply only with the submission of a proposed administrative budget?
Well, it clearly doesn't apply until October 1st. And so I think in this interim period, you would not be operating under that prescription.
So those limits are not there right now?
Not until October 1st.
Okay. And then this person says, gee, it's not really clear what the 3% may be used for. Only for redevelopment obligation retirement, or can it be used for administrative expenses?
I think it can be used for both.
Okay. Next question, we have a council resolution to have the RDA assist our housing authority redevelop some old housing. Will this be in jeopardy if we don't fund they call it the RAID, but the continuation payments, or will be allowed since council has already approved it? So well, the issue is that an enforceable obligation?
Yeah, if council has approved the program, that doesn't make an enforceable obligation. You need a contract, contracted purchase and sale.
Okay. Sort of a follow-on to that, this agency says that they've got a loan between their housing fund and I guess a capital improvements project fund. Our agency fund does not have the funds to pay back the housing funds. What are we required to do in that case?
Well, it's similar to the question that was asked earlier, in that if the agency is dissolved, then the successor agency would succeed to the obligation to pay back the housing fund, but the housing fund no longer exists. So it's sort of a nonsensical situation that creates a lot of doubt.
Yeah. This one says, what do we do about our bond payments that are due in October? Will the successor agency reimburse the city? We don't have any fund balance, and we're generally reimbursed by the redevelopment agency, but the agency going away, increments not coming in, what do we do?
I assume that they're talking about a situation here where they're not the traditional tax allocation bonds that are issued by the agency with debt service paid by the agency, but there's some other form of tax increment-backed indebtedness, certificates of participation, or some kind of a joint powers debt issuance where the agency is obligated by contract to reimburse the issuing entity for debt service. I believe that those will be enforceable obligations, and they will, the successor agency after October 1st will be able to rely on those in reimbursing the city for making the debt service payment.
We just got another question asking, is there a priority order of payments for the successor agency?
Yes, there is. Well, it's not really the successor agency because the payments are now controlled by the county auditor controller. And there is an order of priority. It's a kind of a waterfall that's laid out. I'm not sure I can recite it by memory, but it starts initially with pass-through payments and then county reimbursement for property tax administration, and then bonded indebtedness, then other obligations, and then I think the final step in the waterfall is payments out to other taxing entities with whatever remains after those deductions.
Okay. I just want to note for everyone that we've been on an hour now, and we try to keep these to an hour, but we still have questions coming and more questions to answer. So we're going to try to go, say, another 25 minutes to 30 minutes here. We understand that people have to drop off for other commitments, but we'll try to keep answering questions here. We've gotten a note saying my mention of Mark Hill, somebody must have tried to contact him immediately because apparently he's out of the office. Do we have another contact at DOF? Mark's boss is Todd Giroux, J-E-R-U-E. He's a chief operating officer at Department of Finance. So presumably you could contact Todd, and of course they all work for Ana Montesantos, and her number is area code 916-445-4141, so I'm sure somebody there can direct your question or tell you how to file for that appeal. Okay, next question says, in future years, as project areas, agencies sunset or dissolve, will the remaining agencies have to pay higher amounts to meet the $400 million in future years? Legislation does not address that. Legislation is silent with respect to even the first year payment of $1.7 billion. If some agencies don't make it, will that burden be spread to the others? Legislation doesn't provide for that, so we assume no.
As it's currently written, it doesn't. I think it would take a change in the law to do that.
And another question we got was, well, what is to say that in future years the state doesn't increase the $400 million? And the answer to that is simple: nothing. This is done by statute. It was done with a majority vote. Majority vote could once again come back next year and say, oh gee, we're short of money again in the state budget. Let's take $800 million from redevelopment agencies. So there's nothing that prevents the amount from going up. What happens to obligations entered into after June 29th, but before any resolution or ordinance under AB 1X27? I think we've pretty well covered that. If
there shouldn't be any.
Yeah, so I think there's a pretty simple request on that. Let's see, I guess we've been asked to repeat a question that we got earlier about contracts. If money is appropriated and the project is in design, can you contract for construction? And again,
I think your answer is no. I mean, I don't think it would be enough to have a design contract with the architects to then proceed on to a construction contract with a builder. I believe that's a new agreement.
Again, you know, individual circumstances could yield a different answer, and so, you know, that agency is best to confer with your own either agency counsel or city or attorney or county counsel to, you know, make sure that you know exactly what's in those commitments,
right, and
those documents.
That's true of all of these questions. I mean, we're trying to provide general answers to general questions, and it's always dangerous to do that without having all the facts, and I would advise all of the agencies to consult with your individual attorneys, make sure they have all the facts, not just rely on what we're saying.
Okay. Does undeveloped land purchased with 20% housing funds qualify as assets to be transferred to cities or counties?
Yeah, I think if the city or county has bought money with its housing fund and it elects to undertake the housing functions of the redevelopment agency, that those physical assets like land can be transferred to the city or county. However, they clearly cannot receive the fund or the balance in the housing fund.
Another housing question, can cities assuming the housing functions keep the program income?
I don't see any prohibition in the statute. So if, for example, if the agency transfers land to the city, which is elected to continue the housing function, and the city builds or develops housing there, and there's some income that comes off of that housing, I believe the city ought to be able to keep that program income. I don't see anything in the statute that prohibits it.
Brent, let me ask you this. You know, one of the biggest programs of agencies up and down the state, of course, is our housing program. And there are literally thousands, tens of thousands of units in the state that are under affordability covenants. Either 45 years or 55 years, and you know, most of those have a lot more years to go on them. If agencies go out of business, how do those affordability covenants get maintained?
Well, that would be a responsibility of the successor agency, and they have the ability to continue to receive an allocation of property taxes to pay the staff that's needed to monitor those covenants within these limitations, which may or may not be adequate depending on the size of the program.
Okay. Let's next question. Okay, if the agency dissolves and the litigation is successful, how do we restart the agency? Okay, that's a possibility. If they don't pass an ordinance, they would be dissolved on October 1. Let's say we don't get a Supreme Court decision until December 25th, and it's in our favor.
Yeah, my advice would be to avoid that, would be, I think, for everybody to, for every agency to enact a continuation ordinance, if for no other reason than to avoid the confusion that might occur if they don't. Again, you don't have the money, you can always rescind the ordinance or just not make the payment. As I read it, the result of not making the payment is no different than if you not adopted the ordinance in the first place. And that at least gives you some, the time between now and January 15th to see how the litigation goes. We may or may not have a decision out of the Supreme Court by then, but I hope we will.
Our attorney for that lawsuit, Steve Mayer, has been asked the question, well, will passing these continuation ordinances hurt our lawsuit? And his answer to that is he believes not, because the nature of our challenge, it's a facial constitutional challenge. In other words, what the state has done with AB 26 and 27 is that the state has violated the Constitution. Those provisions that were put there by Proposition 22 are not somehow lessened in their scope or meaning as a result of these ordinances being passed. And so while Steve is neither encouraging nor discouraging that, he is not saying to people that, gee, you're hurting our lawsuit if you follow through. There's a practical issue here, and that is you have to make a decision based upon circumstances and all the what-ifs. And so we're not putting out any advice to agencies about not passing those ordinances as a result of the lawsuit.
I mean, we're hoping we'll have a decision on the stay well in advance of October 1st. And if we get a stay, and if, as we hope, the stay stays the dissolution, the October 1st dissolution of agencies, then it will be a non-issue. If we don't have that stay, then it will be a problem.
Okay. Let's see, question, if land is purchased with 20% funds, but no units have been started, can cities, assuming housing functions, sell that land, assuming no affordability restrictions?
I think they can sell the land. I don't think they can do it without affordability restrictions, because the successor agency would be subject to the same limitations on the use of those funds that the agency would have been if it still existed.
Well, what if they reimburse the fund?
I don't know.
Okay. Is there any penalty, property tax-wise, to a city that elects not to become the successor agency?
No.
Well, there has to be a successor agency of some type, right?
Right.
So that responsibility falls to whom if the host?
If the host legislative body doesn't step forward, then I believe it's the first taxing entity to
Step up.
to declare that they're willing to act as a successor agency. And if nobody does, and none of the agencies step forward, then the governor appoints a three-person board that assumes that duty.
Okay. I can only speculate on who might be appointed.
There's an opportunity for public service.
What is included within the debt service calculation? Specifically, does it include principal and interest? We're talking about the formula that's used to calculate the payments.
Yes, includes both principal and interest.
Okay. There's some ambiguity about whether it's interest on tax allocation bonds or all interest as reported in the state controller's reports.
Right.
And there's a practical issue there, which is that that interest is not divided out in those reports right now. So we're assuming that DOF will use the interest line item that's in the state controller's reports. Okay, does the city, assuming housing functions for a dissolved agency, need to send a letter to the state stating as such, or pass an ordinance, or if so, by what date? Can you help there?
Well, yeah, I mean, I would certainly do something, some official act. An ordinance might not be necessary, but at least a resolution that where the agency or the city makes a record that they are assuming those obligations. So yeah, I would do a resolution.
Okay, what parts of the redevelopment law will cities assuming the housing functions be subject to?
If they're using redevelopment money,
All the same
all the
obligations?
same obligations.
Okay, like
It's-
replacement housing and...
Yeah, I mean, they're going to be, it's the follow the money rule. If it's redevelopment money, it'll be the same obligations. If it's some other form of funding, you have to follow those.
Okay, next question follows from that one, which is that if SB 450 legislation is currently pending that includes many reforms to the housing programs, well, if that's enacted, are those dissolved agencies going to be subject to the SB 450 reform?
It depends. The agency will no longer exist, and so I think some of the provisions, like the reporting provisions, and I mean, that's an analysis that we probably ought to do. I don't think we have done yet, is to go through SB 450 and see which of those would survive for dissolving agencies. I think probably some would and some wouldn't.
Okay. Please discuss the distinction on admin caps for agency staff versus city staff that are performing agency functions. What, if any, administrative caps would a city be subject to? I think that's in reference to the caps that are in SB 450.
Then I misunderstood the question then.
Well,
Let's see.
there are administrative caps in SB 450.
Mm-hmm.
So if the city assumes those housing functions, will they be subject to those new administrative caps?
Not necessarily.
Not necessarily. Okay. If an agency decides to play, can it still create new project areas?
Yes, it can. With the caveat that financings of those future project areas are not going to be able to use the school share of the housing site as set aside, except to the extent that the financings are geared towards certain favored activities. The AB 26 contains a provision that says sometime during the remainder of this section, it's the intent of the legislature to adopt legislation that would reduce this additional payment that agencies have to make on new debt if the financing is used for certain favored activities such as greenhouse gas emission reduction, infill housing, low and moderate income housing. There are a number of different favored policies, and in that event, then the agency would be able to keep more of, though probably not all of that school shed.
Okay. A few more questions that we've been sent. If the agency has a loan receivable in books made from the low and moderate income housing fund, what occurs to that loan? Are future paybacks from the developer to be made to the successor agency?
Yes, I mean that loan is an asset of the agency. It would be assigned to the successor agency, and the successor agency would continue to administer it on behalf of the tax authorities.
Okay. Next question is, will our litigation address the specific validity of abolishing redevelopment agencies by any legislation? If not, will we be back this situation next year, perhaps every year?
It's hard to tell where litigation is going to lead, and whether the court will have to reach that decision as part of deciding this case. It might or it might not. I guess I feel like I'm not really able to answer that.
Well, I think what's on the mind of the person who asked this question is that if we challenge this set of statutes and they're thrown out by the Supreme Court, does the state just turn around next year and pass something similar, which also violates Proposition 22?
Well, of course, we can't stop the legislature from continuing to violate Proposition 22, but I think hopefully the decision of the Supreme Court will give everyone clear guidance on what the legislature can and cannot do with respect to redevelopment funds. But you can't guarantee that, unfortunately.
We need a real clear, comprehensive decision out of the court in that respect.
We do.
Okay. This is another question relating to the question and answer piece that we sent out. Draws a distinction between on how much tax increment can be used for agency staff versus city staff on contract to perform agency functions under AB 26 and 27. And the question is, well, why do we do that?
Well, the limitations, first of all, most agencies has no staff.
Right.
Most agencies contract with the city and its city employees that perform agency functions, and they're paid by the city and their city employees. The limitations on staff in AB 26 appear to be directed to agency employees. And so for all but a few agencies, it just simply won't be applicable.
Okay. Here's a few kind of follow-on questions. This person is asking about what about cleanup legislation that would facilitate agencies making the first-year voluntary contribution? Well, there have been some comments made by the President Pro Tem of the Senate that there's going to be yet another bill that deals with redevelopment issues, and we've been told that there may even be some sort of task force of legislators from both the Assembly and the Senate tasked to work on this activity. Our board is yet to discuss possibilities of cleanup legislation, but here's the point. This legislation is unconstitutional. It's unconstitutional. It violates Proposition 22 and other provisions in the Constitution. No amount of cleanup legislation can change that unless that cleanup legislation simply replaces the statute. That's not going to happen. This legislation takes a gigantic amount of money from redevelopment agencies. Cleaning that up is not somehow going to change the amount of money that's being taken from agencies, given that it was done in order to fill a budget hole, even if that amount of money that they're expecting to receive may not materialize. And so there's an old adage here in Sacramento, which is you don't amend a bad bill, and I doubt whether it makes much sense to amend a bad law, unless that means amending that law to the point of throwing it out. So I don't think we're going to make it easier for the state to take your money and to violate the Constitution. That just doesn't make sense to my way of thinking about any cleanup bill. There have also been some suggestions about how this cleanup legislation might actually make your life worse, as opposed to making it easier to comply with AB 26 and 27. And so I wouldn't place a lot of hope in a third bill or somehow cleanup legislation making the many problems that are surrounding AB 26 and 27 go away. This person wants to know, what was the actual time that the governor signed AB 1X26 or 27? We think that was signed on June the 28th, about 4 p.m. And I assume the reason a person might ask that is, were those bills signed before the budget? We think they most assuredly were. They were probably signed in violation of the Constitution, because the Constitution says the governor cannot be sent trailer bills with appropriations prior to being given a budget. He didn't sign the budget until the next day, June the 29th, and that's the day that we're using as kind of that key date from which you cannot do certain kinds of activities. The next question is, will this be the last rate, or will there be more next year or the year after? You know, this legislation already takes money every year from now and forever. And as I said earlier, nothing prevents the legislature from increasing that amount of money. What is the guarantee the state will not come back next year or take more, and there is no guarantee? We're running out of time here. I want to cover another issue, Brent. We've gotten questions from people who either have special legislation in place to convert military bases, and others have asked questions about, well, do these laws, 26 and 27, apply to the military base conversions?
There's no exception for military base conversions.
And then the next question comes, well, will they be covered by the litigation that CRA and the League intend to file?
Yes.
And so the answer here is that those special redevelopment projects that are military-based conversions, if we win the lawsuit, they win too.
Yes.
And they also are subject to those provisions of AB 26 and 27. So there's not somehow an exemption in these laws for military bases.
We're all in the same boat.
Okay. All right. Let's see. What else do we have here? We're just asking you to repeat an earlier answer. Can you please restate your understanding of new contracts made after January 1, 2011, but before June 29th, 2011? Are they valid?
Third-party contracts, clearly valid. Intramural contracts between the agency and its host legislative body, the legislature would clearly have those be invalid. Some question as to whether the legislature can do that.
And so there might be individual challenges to any actions by the state to somehow undo those particular obligations that were entered into between January 1 and June 29th.
Yes.
So we're not going to be able to give a complete answer on that one. That's going to be subject to individual circumstances. I have a feeling that many attorneys will defend those and say that they are valid. Okay, another question, we've been asked to repeat the status of our legal challenge. It has not been filed, but we expect to file any day now, and when we do file, there'll be two actions. There'll be a request of the Supreme Court to stay implementation of AB 26 and 27, as well as the primary complaint, which is that this legislation violates the Constitution, particularly Proposition 22 passed by the voters overwhelmingly, 61%, just this last November. I think we've answered all the questions. Any points that you wanted to add that I didn't ask you about?
No, keep the faith.
Keep the faith, you know, keep working and keep doing the best that you can. Hopefully there is a press event coming near you. Our team is still working to publicize the injustice of this legislation and the impact that it will have on local projects. You can help us do that by continuing to point out to your legislative body and to your local public, your constituents, your people who are interested in redevelopment, what this legislation will mean. Literally hundreds of projects I know will be canceled or delayed or somehow reduced in scope as a result of this kind of money being taken away from agencies. It's important that you let people know what this means to your local community. We've been getting a lot of press. Members of the press are interested in covering this issue. You should work with them to let them know the circumstances in your locality. In addition, starting yesterday, we're having press events, and we'll have those around the state so that your local elected officials can say firsthand in a public setting what this legislation means to your city or county. So keep up the public information. That's important to our being able to win this battle. Thank you for joining us. Thanks to Brent for being with me today. Thanks to Jeff Radies and Tom Hart, who are in the room here with me, who brought you this production. Thank you very much and have a good afternoon.